I'm Hazel Genn, Dean of the Faculty of Laws. It's my great pleasure to welcome you here this evening for the 2012 UCL Bindmans Annual Debate. And the subject this evening is freedom of the press versus privacy rights, although we've been having quite a long debate here about the meaning of the title, and I'm sure the panel will work that out later on. The series has been running since 2005 and evolved from an idea of Stephen Gross, who is a partner at Bindmans and who I think is here this evening, but I can't see him. Hello, Stephen. He's there. Who's been put in a huge amount of work in organising these in previous years. We're very grateful to you for that. The topics we've had in the past have included multicultural Britain, liberty and security, new rights for all, is it time to trade in the Human Rights Act, and other topical subjects. This year the debate's been taken forward at Bindmans by two of their partners, Tessa Jowell and Tamsin. We're delighted to continue the string of highly successful debates, and I'm personally delighted that we have such a very distinguished panel here with us this evening on such a very topical subject. Before we get stuck in, I should just tell you a couple of housekeeping items. First of all, that this evening's proceedings are being filmed. The panel has agreed to this, but you just should be aware of that, that the film will be posted on the UCL website before anybody asks an inflammatory question. I should also ask you to turn off your mobile phones. Although I think that the reception here isn't great, phones do tend to ring, so do please turn them off. I'm looking forward to a very stimulating evening. It gives me great pleasure now to hand over to Tamsin, who's a partner at Bindmans, who's going to introduce our panel and our chair for this evening. Thanks very much. Thank you, Tamsin.
I'm here to introduce the panel and the chair and the debate, which is not a traditional in the sense there are no winners and no losers at the end of this debate. Instead, we're going to hear from each of the panel in turn and then open the floor to questions, observations, information, anything you want to contribute. First of all, we're going to hear from Tessa Jowell, who you'll recognise, who is MP for Dulwich and West Norwood, formerly Secretary of State for Culture, Media and Sport, and now Shadow Minister for the Olympics and Shadow Minister for the Cabinet Office. Tessa has experience of the media from both perspectives, as a policy maker and as a victim of press intrusion. Secondly, we'll hear from Martin Moore here, who is an academic who has researched and written about the press and regulation for many years. He's now Director of the Media Standards Trust, whose aim is to improve standards in news media. And more recently, he's adopted a campaigning hat as part of Hacked Off, a campaign group which has been supporting victims of press intrusions in the Leveson inquiry and keeping the inquiry on its toes. Thirdly, we turn to someone who really understands what press regulation would mean. Gill was in-house legal advisor at the Times and is now legal director at The Guardian. She has real cold-face experience of dealing with these issues in practice, the tension between campaigning investigative journalism and individual rights, the pressures of news journalism and the demands of journalists and editors. And finally, we'll hear from Max Mosley, formerly head of Formula One, and since his well-known brush with the news of the world, a formidable campaigner for changes in the law to protect privacy rights, going all the way to the Grand Chamber of the European Court in his efforts to change the law to require the press to warn individuals about potential privacy intrusions before publication. The debate will be introduced and controlled by Hugh Tomlinson QC, one of our best-known media silks, and someone I know to be the strategic mastermind behind the recent successful judicial review of the police in the phone hacking scandal and the voicemail interception litigation. I really hope everybody feels able to participate fully in the debate, ask lots of questions, and I'll see you at the end for drinks. Thank you.
The format, as Tamsin said, is we're going to have 4 speakers, each 5 to 10 minutes. But the purpose of this debate is really to inspire you to ask questions of the speakers, and we're going to have a generous time for questions at the end of the contributions from the platform. The topic today is freedom of the press against privacy rights. Is it time for Parliament to draw the line? As we all know, Parliament, perhaps under the improper pressure of the media barons, has kept well out of these areas. Parliament has avoided legislating on privacy despite many attempts to introduce privacy rights over a period of more than 40 years. And Parliament has also kept out of any kind of statutory regulation of the press. These matters have been left to the good sense of editors and journalists. You may think that that's not a very sensible yardstick to use, and to the ordinary law of libel and the law of privacy as it's been developed since the Human Rights Act came into force. Now, this debate has become particularly acute, as we all know, over the past year as a result of the phone hacking scandal, which focused on the news of the world but is generally believed to have tipped over into other newspapers, leading to the setting up of the Leveson inquiry in July of last year. Now, at this point, the question arises, at this point in the history of media regulation, the question arises very acutely as to whether Parliament should draw the line. And what our speakers are going to talk around are essentially two areas. The first is whether the time has now come for Parliament to bring in a law of privacy, a privacy statute. The second is whether the time has now come for Parliament to impose some form of statutory media regulation. Older members of the audience will remember the Calcutt Committee in the early 1990s, which grappled with both these issues together. And what happened was a very British compromise. It was said, yes, here is a privacy law, and here is a set of statutory provisions to regulate the press, but we won't put them into force because we'll give the press one more chance. And Mr. David Mellor, a politician doubtless long forgotten, save for the media intrusion into his private life, Mr. David Mellor famously said, "The press are drinking at the Last Chance Saloon." The Last Chance Saloon has remained open a very long time indeed. And the question now, and those of you who watch Leveson TV of an afternoon, doubtless most of you are glued to the screen like I am, will notice that Lord Justice Leveson very often says, "I'm not going to be drawn into the Calcutt trap." The Calcutt trap was listening to the honeyed words of the media and keeping statutes out of their affairs. Well, is that something that, are those assurances that he should now be doubting, or should he accept a new set of tougher assurances from the media? So on the one side, there are those who say freedom of expression is so important that once Parliament starts interfering, it ends in Zimbabwe or in Beijing. And there's another set that says, on the other side of the debate, that the position that the press are too amoral, too out of hand, to be permitted to regulate their own affairs, and the time has come for our elected representatives to draw some rules for the game. You will hear both perspectives in the course of from our speakers, a range of views, and then after 30 or 40 minutes, we'd like to hear your thoughts and your contributions. So with that very short introduction, I'll invite Tessa Jowell to make the first speech from the platform.
Hugh, thank you very much indeed. And Tamsin has introduced me to you. I want to talk more particularly as a former Secretary of State for Culture, Media and Sport who grappled with many of these issues and was for 13 years a member of the government where I was going to say the management of the media, the handling of the media was a part of almost every single day. But I also want to say that I'm not going to talk about my own experience of the the horrors of phone hacking. I'm prepared to, I'm happy to answer questions, but I mean, I don't think that this debate should be contracted down into sort of curiosity about what happened to individuals, because this is a moment in time to try and get a better settlement between the public and the media than has existed for certainly the last 25 years, or if ever. There's always a temptation to look back to a golden age when things looked better. The other mistake is to see this only through the prism of the relationship between politics and politicians and the media. And again, this issue is much bigger than that if it's to be dealt with properly. I suppose the only reference I want to make to my own case is my thanks to Tamsin and Hugh, who looked after me and sorted me out with the monsters at Newsgroup, and I shall always be grateful to them. Now, let's get back again to the argument and to say that my risk with all of you is to talk too much about this as a relationship between politics and politicians and the media. Politics in which I believe, I'm proud to be a politician. But as I say, the issue extends very substantially beyond that. And again, in questions, I'm very happy to talk a little bit about, or say more about where I think politicians are culpable and where I think the media are egregious. But the Levinson inquiry, as we know, was set up. As I'm talking about this, I'm thinking the things I'm not going to talk about may be much more interesting to you than the things I am going to talk about. So I'm not ruling them out, as I say in the questions, but I do feel duty-bound just to lay the argument out. I mean, what is it took the cataclysmic shock of the unravelling of the News International justification, the concealment, the implication, the truly shocking implication of an apparent conspiracy in which the Metropolitan Police were part, to cast the bright light of public concern on this, remembering that only about 12% of the public who read newspapers believe what they read. I think it's a little bit higher if you read The Guardian or used to be The Times or the Independent. But the public, let's not forget that the public are in the game on this and are wise and discerning. There is a symbiotic relationship between politics and the media. And I don't think that that is nearly as craven as a lot of the commentary has suggested. I think it's reasonable for people to believe that politicians are, by and large, and the majority are people of integrity who come into politics only because they think that politics is a way of improving the conditions of the world beyond their own narrow self-interest. And I think that to pretend that somehow this whole issue was wholly shaped by this private and corrupt relationship misses the point. It's also important, I think, just to remember that nobody was that interested in celebrity revelation, or indeed the fact that politicians and sportsmen and women, people generally in the public eye, experienced intrusion, because the wider public just think that that's what happens anyway. They also rather think that this is the kind of publicity and relationship with the media that that these people, who are remote to most of their lives, court. But in all the years that I've been in politics, I have just believed passionately in a free press. And whatever the pressure to constrain the press for convenience, for whatever motive, I've always believed that the alternative was worse and that there must be another way of getting this, this better settlement. But the status quo is now unsustainable. And I think that it's extremely important that as Lord Justice Levinson proceeds with his inquiry, I mean, there is no sense of scores being settled because, again, I feel that as politicians, we hold this responsibility or the potential for regulation at some level. We hold this as guardians of the broader public interest. So here are the principles that I think that should guide this debate, which is still very much in the process of being shaped. The first is that the press should be free, but with a much clearer understanding about what is within and off limits in pursuit of a story. I mean, I remember getting into all sorts of debates about reality television, what was acceptable and what wasn't acceptable. And just because it is possible to do something doesn't mean that it's the right thing to do. Just because you can show something on television doesn't necessarily mean that it's the right thing to do, and exactly the same goes for journalism. The second principle is that the new system, in whatever form it takes, must be independent, both from political control, but also independent of serving editors or those who have a discernible vested interest. And one of the things that has always disturbed me quite a lot is the kind of non-aggression pact that exists between editors, between journalists, whereby, they dole it out to everybody else. My God, do they hate it when it's doled out to them. But basically, there is a presumption that they don't attack or criticize each other. So the third principle is the need for plurality and balance. And our press works best when it does reflect the diversity of the argument. And I think that we should support the work that the Culture, Media and Sports Select Committee are currently undertaking, looking at plurality, not just in relation to print media, but also in relation to broadcast media. So the fourth principle requires recognition of the acceleration of what 10 years ago, when I took the Communications Act through Parliament, we described as convergence. The fact that probably in less than 5 years' time, it will be impossible to distinguish between streaming, blogging, tweeting, and a newspaper. People will receive their information in a multitude of different ways, much of it increasingly generated by themselves. Now, I mean, the great risk of the Levinson inquiry is that it solves yesterday's problems rather than looking forward to a settlement for the next 10 or 15 years. And I think the last principle is that redress under whatever new regulatory form is devised must be available to all citizens and not just to the rich and powerful. And that has been the problem, the obstacle for so many people in bringing privacy cases, and also with this government's decision to recast the rules for no win, no fee. But there are newspapers who I think quite some time ago took steps to put their own conduct on a transparent and sort of ethical footing. Internal readers, ombudsman. I mean, the enforcement, progress could be made with the enforcement of an editor's code and the clear accountability of editors for the behaviour of their journalists. So I think that is that's the broad frame of the argument. But let me just finish by saying this, that I care a lot, as I'm sure all of you do, about the quality of our public life, the people who put themselves forward for positions often of great responsibility, difficulty, involving, you don't get paid for it, but you are expected to get a lot of satisfaction from the time you give. And unless we sort this out, we are going to see our public life gradually degraded, because good people who can do other things with their life and time will simply not come forward. They will not come forward if they believe that by taking a particular public appointment, or going into politics or other forms of public life, they're going to live in dread of the 5 o'clock call on Saturday and face the prospect of being all over the papers on Sunday, their lives trashed, their families distraught, and so forth. So, there is a sort of shared investment about protecting our public space. The last thing I would say, the very last thing I would say is, when I was Secretary of State, I always promoted media literacy. And media literacy is like learning a new language. Identifying the Non-Aggression Pact in action, identifying the motive in a story because of the byline of the journalist who's written it, identifying the timing of stories, knowing that perhaps there are other events and consequences that this story is intended to enhance or to undermine. And I think that we should therefore look, this is my last point, we should look beyond just this relationship between the regulator and the regulated, and invoke a much more sort of competent and engaged and assertive public in pursuit of the excellent journalism, the press freedom, and the greater and more decent occupation of that public space that I think we all want out of this whole drama.
Thank you very much. Next speaker, Martin Moore.
Thank you. I think it's quite easy at the moment to get quite lost in the present. I'm certainly guilty of it. I spend huge amounts of my time down at Court 73 at the Royal Courts of Justice, participating in or observing the Leveson inquiry. So I think the first thing that I wanted to say is that we need to step back when it comes to privacy, because privacy is far bigger than the press. I think it's quite easy to forget that. In January 2010, Mark Zuckerberg was talking to Michael Arrington, the founder of TechCrunch, and he said to Arrington that he thought the age of privacy is over. And he said if he was going to create Facebook again from scratch, he would start by making all user information public. And over the last 2 years, Zuckerberg has done pretty much that. Most recently, anyone who has a Facebook page will know that most recently with the Facebook timeline, where your past is made public by default unless you choose to hide it, or will be. And much as I hate to admit it, when you look at some of the things that people put on Facebook, the 27-year-old now paper billionaire, Mark Zuckerberg, I think has a point in the sense that the practical boundaries between private life have changed enormously. and the practical constraints on recording and publishing have virtually disappeared. Anyone can record video, photographs, audio, and anyone can publish. If you want, you can go to your flatmate's bedroom, film him or her having sex, and then in a couple of clicks, publish it on the net. And actually, that's almost exactly what did happen in New Jersey in 2010. A young student called Tyler Clementi at Rutgers University in New Jersey, his roommate decided to go into their shared room and film Clementi having sex with another man, and then published it on the net. Tyler Clementi had not come out as gay. When the video was published, he killed himself by leaping off the George Washington Bridge. The removal of practical constraints necessarily means that if we want to protect private life and maintain private space, then the practical constraints will have to be replaced with something else. Make no mistake, no matter what some of the shriller tabloid headlines said last year, people do think that we should have some sort of privacy protection. A poll last year by Comres found that 95% of people believe it's important or vital that people have a right to respect for privacy, family life, and the home. Now, preferably, these would be cultural constraints. What I mean by that is that people would recognize the line between public and private and respect that line. But the press makes a living out of, or partly anyway, out of transgressing this line, and sometimes the transgressions are entirely legitimate. They're to investigate stories of public interest. Sometimes they're illegitimate, whether they're hacking into voicemails, searching for gossip, or breaking into personal email accounts, as the Times confessed to doing this week to find out the identity of Nice Jack, the anonymous police blogger who won the enormously prestigious Orwell Prize. I should, statement of interest, we run the Orwell Prize on behalf of the Council of the Orwell Prize. And where there are no formal constraints, then certain news outlets have shown that they'll use any means necessary to get to personal information. In Sharon Marshall's book, Tabloid Girl, that she's sought to distance herself from the Leveson inquiry, she wrote that a tabloid hack can get any information that they want, on anyone. There are ways and means. Newspapers used fixers, blaggers. There was one freelancer who was known for being able to pull people's medical records. No one quite knew how he did it. Where cultural constraints don't constrain publication, people have sought legal constraints based on the European Convention of Human Rights. These people are in effect saying, this is where I believe my private life begins and your right to publish ends. It's entirely natural that people should try to get legal protection or redress when the press try to intrude on or publish details about their private life. But it's equally natural that journalists should challenge where the line is between private and public life, most notably when they think people or organizations are hiding behind things that they believe are in the public interest. But it's absurd not to acknowledge the tensions between the two, as some newspapers have been doing last year. We now have privacy protection within the law, thanks to Article 8 of the Human Rights Act. Since 2000, precedents have been formed around the Act due to cases such as Max Mosley's, and they will continue to be so. There are issues around the application of the law and significant questions regarding access, but that such protection within the law exists is entirely sensible for the reasons outlined already. The real debate, I'd suggest, is not whether we should have privacy protection within the law, we should, or if Parliament should pass a law that protects privacy, it has, but how we protect the right of journalism to intrude when it is in the public interest. Right now, there is no public interest defence spelt out within the law. I'm referring here to content rather than process, since we have the Reynolds defence. There's no public interest defence in the Regulation of Investigatory Powers Act, or in the Official Secrets Act, or in the Computer Misuse Act, or in the Incitement to Misfeasance or Misconduct in Public Life. There are relatively weak public interest defences in defamation and in confidence, even in the defamation bill currently going through the House. Lacking such a defence can put journalists who are acting in the public interest in a very vulnerable position. The Metropolitan Police sought a court order under the Official Secrets Act to make Amelia Hill of The Guardian disclose her sources on phone hacking. Or it can prevent the publication of news that is in the public interest. In the case of the Financial Times, when Northern Rock prevented them from publishing a briefing memorandum that the FT claims was squarely in the public interest because the public interest defence in the law of confidence was so weak. Nor is the idea of including a principled defence of public interest within the law like nailing jelly to the wall, as some people have suggested. We've prepared a number of different public interest definitions, including the Editor's Code of Practice, the BBC's, the Ofcoms, the NUJ's, and found a significant amount of overlap between them. And just to cite 5 specific things. Number 1, exposing or detecting crime or serious impropriety. Number 2, preventing people being misled by some statement or action of an individual or organisation. Number 3, disclosing information that allows better decision-making about matters of public importance or incompetence that affect the public. Number 4, protecting public health or safety. And number 5, tackling fraud or corruption. Now, you might have noticed that I have not included broad references to hypocrisy or to role models, because they can be and are very frequently misused. Nor have I included the defence that there is a public interest in freedom of expression itself, as is included in the current PCC code, because this seems to me a get-out clause for virtually anything. One could as easily say there is a public interest in private life. Indeed, what's out is almost, and perhaps more, important than what is in the public interest defence. Sir David Calcutt, when he published his 1993 second report, was highly critical of the industry's changes to the code to widen the public interest defence. And watching the Levis inquiry, particularly since Christmas, it's clear we're a long way away from a consensus on what exactly constitutes the public interest. You only need to look at Maz Mahmood's testimony to see that. Which is why I suspect there will be many energetic arguments over the next few months. Watch this space. But the eventual conclusion of a public interest defence in law would, I think, achieve 2 substantial things. It would better protect journalism that's in the public interest, but it would also better define the line between public and private, and through the precedents that built up around public interest would give good journalists the confidence to intrude, and bad journalists make bad journalists conscious that they were treading on very dangerous ground. So to return to the terms of the debate, my appeal to Parliament would be don't pass a privacy law, pass a public interest defence.
Thank you very much. The next speaker is Gill Phillips, who has the misfortune of sitting next to me, so I can rigorously enforce all time limits.
And I would just like to say that I'm sure that the time I was given to speak has got shorter and shorter. And
You've already been given the 2 minutes.
yes, I know. And my speech got longer and longer, of course. I feel rather like Daniela in the Lion's Den as the sort of sole press representative on the panel here tonight. But I'm going to have a go anyway at trying to put some of the sort of other arguments from what would be called, I suppose, the press perspective. It's said that the state of a democracy can be measured by the health of its press, and it's fair to say that parts of our media have been found to be very sick, but it's vital that we don't kill the patient in attempting to cure the ill. There are 3 points I'm going to make. One is that I don't believe in state regulation, but I do think there need to be substantial changes to the way the press is regulated. The phone hacking scandal has led to a clamour that self-regulation has failed, and that there's a need for better, tighter, more regulation, ranging from direct statutory regulation to a statutory backstop to statutory mechanisms which can be used to enforce, carrots and sticks, and a myriad of hybrid variants in between. And not a day goes past, I think, when another proposal doesn't come out from somewhere. As the various possibilities are discussed, it does seem clear to me that opposing statutory regulation does not necessarily mean opposing any use of the law to make the system work. But we do need to keep a sense of perspective. What we need to remember about the phone hacking scandal is that it boils down to criminality in a single newspaper. That's not a failure of self-regulation, but rather a failure of internal management, and more worryingly, a failure of the police to investigate and prosecute. Crime is crime. The police had all the evidence back in 2006, but they chose to ignore it, and they ignored it not once, but several times, as indeed was acknowledged by them yesterday. There are still many questions to answer, not least about the far too cosy relationship that had developed between some elements of the press and politicians. Complaints about the press are nothing new. Within 10 years of William Caxton setting up the first printing press in London in 1486, Henry VII was complaining about forged tidings and tales. Throughout history, ever since the arrival of printing, there have been attempts by the state to regulate the press. In 1542, the Privy Council took action against individuals for seditious, unfitting, or unseemly words and evil opinions. In 1638, John Lilburne was dragged through the streets and put in the pillory for distributing copies of an unlicensed pamphlet criticising Charles I. In 1663, a gentleman with the fantastic name of Sir Roger Lestrange, who had the grand title of Surveyor of the Press, Lord Justice Leveson listen on, was responsible for licensing printers, and he published a pamphlet called Considerations and Proposals in Order to the Regulation of the Press. Within months of that being published, the premises of one John Twyn of Cloth Fair were raided, and he was found guilty of unlicensed printing. He was hung, disemboweled and quartered. Hopefully Sir Brian isn't thinking of quite such drastic measures. It wasn't until 1695 that John Locke successfully argued for the abolition of the Licensing Acts, but that wasn't the end of the state attempts to control the press. The 1712 Stamp Act, which taxed the press firstly at a penny a paper, rising over the years to 4p a paper, took a large slice out of newspaper profits and apparently resulted in journalists taking bribes in order to make a living. Does this all sound terribly familiar? The ruling Tories paid secret subsidies to pro-government newspapers using public funds. Sir Robert Walpole bribed Daniel Defoe to write pieces that ostensibly opposed him. When George III came to the throne in 1760, he appointed as his Prime Minister the Earl of Bute. Bute used public money to bribe one Tobias Smollett to produce a weekly newspaper, The Briton, to pour abuse on his predecessor, William Pitt. That indeed is what prompted Wilkes to launch his satirical attack on Bute and the monarchy. Wilkes and everybody involved with that were hounded and arrested and accused of treason. The so-called freeing of the press, which began with Gladstone's free trade budget of 1853, and the removal of stamp duty, and the eventual abolition of what became known as the taxes on knowledge, created an environment which allowed the mass media of the time to act as an independent critic and formulator of public opinion, and that's really what it's still trying to do today. Even after the removal of the taxes, the government of the time couldn't quite let go of control. It imposed a surcharge on papers if they weighed more than 4 ounces. Perhaps Lord Justice Leveson should consider that as an option. It would probably help the trees, if nothing else. So what does history tell us? It tells us 3 things. One, that the instinct of those in power to control the press is a strong one, which should be resisted at all costs. 2, that regulation by taxes and laws distorts people's access to the truth and can lead to undesirable side effects, such as bribery and corruption. And 3, that the struggle to free the media took hundreds of years and is an achievement that should not be lightly disregarded to satisfy short-term demands. So if I'm standing by the hard-won defence of a free press, but also acknowledging some changes need to be made, how do I suggest the present hue and cry for regulation be best met? Toothless or not, and its own inquiry into the Guardian's hacking allegations was feeble, the Press Complaints Commission was never constituted to address criminal conduct. The issue here, perhaps, is that self-regulation has been inadequately applied, and that what is needed is a PCC max, if I can borrow a phrase from the debate over Scottish independence. Now, I'm not going to go into the various proposals that there have been. I'm happy to elaborate on that later if need be. And there are some very difficult questions to be answered. How do you deal with bloggers who thrive on being marginal? To come up with a solution as to how you regulate them in the modern media ecosystem will probably still be challenging us in 20 years' time. I think you have to accept there are always going to be a feral band at the outer edges who will escape sanction and censor. History tells us it's always been that way. Look at the role played by underground pamphleteers, or the tradition of oral seditious songs and poems during the French Revolution. There's already a mass of complex laws. Neither the press nor the public need more top-down regulation. All that does is add layers of complexity and confusion that end up obscuring the public's rights. And we certainly don't need a law of privacy. The battle of privacy over privacy, as I see it, is simply part of a wider war that is raging about who controls access to information. Is it the state? Is it the courts? Is it the individual? Is it newspaper editors? Thank you.
My powers are greater than I thought. Finally, the final speaker tonight is Max Mosley.
Thank you very much. Well, first of all, I think it's necessary to be very clear. No one that I know of anyway would dispute that we need a free press. We certainly don't want a press that is controlled by the government. But equally, we don't want a government that's controlled by the press. And that's something that we have had to a considerable degree for the last several years. So it's gone from one extreme, the historical extreme, which Gill explained, to the modern extreme, which is somebody sitting in New York, who's not even a British citizen, effectively deciding what our government will and will not do. And it doesn't just apply to the current government. It also, with all respect, had enormous influence over the previous one. Witness that when Tony Blair went to Australia in 1995 at Murdoch's suggestion, when he wrote about it in his memoirs, he recorded that somebody in the Labour Party had criticised him for doing this, to which he replied, "Have you ever heard of Faust?" Well, it's pretty alarming when that's before he was even elected. But coming on to the question that's in front of us, do we want a statute? I would suggest we do. But before explaining why, I think one needs to understand one point, which is the Press Complaints Commission has failed, not in its rule-making capacity. Its rules generally have been quite reasonable. Where it has failed is that it has not had the means to enforce its rules. So the very first thing you need, if you're going to have rules, is a means to enforce them. Obviously you've got laws, you've got defamation, privacy, all sorts of laws, but the actual rules which govern the conduct of the press, which are laid down at the moment by the Press Complaints Commission, they too need to be enforced. But how do you enforce them without some form of state control? Well, I would suggest that the solution consists of separating out the rule-making body from the body which enforces the rules. I would suggest you should have a press commission, which would be very much similar to the existing Press Complaints Commission, to make the rules, and then a completely separate tribunal to enforce them. That tribunal would be independent of government, independent of the press, but it would have to have the power to enforce its regulations on those who may need them enforced. You cannot enforce rules without power. And I mean, it's no good saying some of the editors are responsible, they'd never do anything bad. That's like saying most motorists are responsible, they wouldn't do anything they shouldn't do. but you still need laws for the people on the edge, the peripheral people. And so I would suggest you need a statute in order to enforce your tribunal. And the people in the press who actually become irrational when the word statute is mentioned, because they see all sorts of government control, they don't seem to understand that if you have a statute which does no more than allow the rules which the press themselves make in their commission to be enforced, that is in no sense government control. So I would suggest that splitting thing, and I think the point that Leveson continually makes, that statute or no statute is not binary, it's much more complex than that. And all you need is a system which gives you a statute without the danger that the government could use that statute in some way to control the press. Now, there are various other points, but we've got very little time. I'd just like to say something about the public interest, because I would include that, if it were me, in the statute. The public interest, I think, should be defined, but if it were me, I would define it very broadly, rather as in the Freedom of Information Act guidelines, where it's just the public interest is something which is in the interests of the public, absolutely broad. And then you would have a number of presumptions which you would presume were in the public interest. They were already listed, actually, by Michael Moore. And I would also have some presumptions are not in the public interest. Medical records, sexual behavior, things to do with children. But in both cases, those presumptions would be rebuttable under my system. Now, you could do that in a statute, and it would give guidance to the courts, which I think would be useful. Final point on the statute, there should be one prior notification. Because if you're going to expose somebody's private life, if you're going to discuss things which are private to them, then once you've done it, once it's out, even if it's completely illegal, no power on earth can make it private again. No. Once it's been published, it's out. There's nothing you can do. The only remedy in privacy is to stop publication. So you must have the means to do that. To me, that is so obvious that it's virtually self-evident. I just finish by making a point about private life. Tessa Jowell said, I think quite rightly, she wasn't going to go into her case, and I won't go into mine. But I would just like to say that Paul Dacre, who is of course, the famous editor of the Daily Mail, who was stayed for yesterday in Leveson, and apparently coming back on Thursday at 4 o'clock. I think that's not to be missed, but we shall see. He said about me that, twice actually in writing, that I've been guilty of unimaginable depravity. Now, of course, that raises immediately the question of what is, in his mind, ordinary depravity. Because it makes you think that he's got a very, very strange idea about sex. He's obviously never been on the internet. He's never looked. And I have this awful image of Mr. Dacre and his sex life, and I'm afraid this is a bit private.
Don't go there.
Well, I'm not going to film him, and I'm certainly not going to put the film on the internet, but I do picture him drawing the curtains, turning out the light, and assuming the missionary position. And somebody with a life as sad as that should not be allowed to comment on the sex life of other people.
Or run a national newspaper.
Or as Tessa says, run a national newspaper. Thank you very much.
Thank you very much to all our speakers, and we're left with the image of Paul Dacre, fortunately behind curtains.
Oh my.
We've had a wealth of suggestions and interesting, imaginative, novel suggestions as to how a statute might function, and a number of powerful arguments as to why a statute shouldn't be functioning, which is exactly what a debate should be doing. So I'm now going to open it to the floor. There should be people with microphones. So if you have a question for any of the speakers or a comment, if you put up your hand, but don't say anything till the person with the microphone appears, because otherwise it won't be recorded.
Thank you very much. My name is David Rubain. I'm Chief Executive of the Quality Challenge Unit. I have a sort of a question for the panel, and I hope this is within the rubric of the discussion, but it's really to do with incivility and the press. Some of this has been discussed before the Levinson inquiry, particularly, for example, the evidence given by Women Against Violence Against Women and associated organisations about how women are portrayed, which at its worst borders on misogyny. And there are many other instances. I mean, incivility is probably the nicest way of putting it. The worst way is deliberate manipulation to scapegoat or attack a group of people. And I'm struck by the fact that in public life there are very legitimate debates to be had around a whole range of things. And for example, at the moment, there are debates over welfare benefits for disabled people. They're entirely legitimate debates about what they should be, the level of them, and indeed whether they should be means tested. But at the same time, there is discussions in some parts of the media whereby disabled people are characterised as being scroungers or lazy or incompetent. And I can think of many examples, a recent one being where there was an attack on a disabled couple who were claiming disability benefits when they'd won the lottery, I think. In fact, the benefits that they'd received are disability living allowance, which is non-means tested. Now, there is a legitimate debate about whether it should be means tested, but clearly that wasn't what the approach of that particular newspaper was. It was to ramp up hostility, it seemed to me, towards a group of people, and it did seem to me to be not coincidental that it was the same time as this legitimate public debate was taking place. My question then is, it seems to me that this doesn't raise issues so much of, well, it certainly doesn't raise issues of defamation or privacy. No individual was defamed in that, arguably at least in that sense. But there is an increasing stridency amongst parts of the press to scapegoat, attack, marginalise groups of people who are already vulnerable. And I'm sure many people here could have lots of examples of that. I don't know what the answers to this are in the context of the importance of free press, but I'd be very interested in any views of the panel.
Thank you very much. Martin, would you like to start?
Yes, I'll start because I was giving oral evidence at Levinson this morning, and I was sitting alongside someone called Will Moy, who runs an organisation called Full Fact. And one of the things that Will spoke about quite a lot was around the issue of accuracy and the importance of accuracy, which has not been ignored by the inquiry, but clearly the inquiry has been focused very much on privacy, and particularly the issue that you raised, which is the issue around distortion and inaccuracy and misrepresentation of groups as opposed to individuals, because of course most of those that appear are individuals. I think his evidence ought to be online now, but I would highly recommend looking at it because he's collected up many of the specific articles that they've fact-checked, and a whole section of that is on the representation of benefit claimants, because there are certainly some quite serious allegations that not only was the press deliberately misrepresentative in terms of its use of statistics, but that actually there was some degree of collusion between the DWP and some of the press on this. And that, as Will said, I think that certainly the issue there is who is the complainant, because they can't take any sort of defamation proceedings in that sort of situation, particularly when it's actual inaccuracy and distortion in reporting. That's what you'd hope the role of a regulator would be, to try and deal with something like that, particularly when at the moment it can't at all. It doesn't. I mean, it does take third-party complaints, but it finds it very difficult to take particularly complaints from groups and minority groups. So.
Tessa, do you think there's any role for statutory regulation to deal with this kind of issue, or do you think it's a matter of culture and proper manners?
Well, I've been thinking about this. I think this is very difficult, and I think that there are newspapers whose stock in trade is to sell. Their marketing policy is to scapegoat migrants, people who are mentally ill, people who are disabled. It used to be people who were gay or lesbian, and on you go. And that is their stock in trade. And I think that because these are newspapers that are selling a view of the world, and a view of the world which is certainly not represented in Britain today, certainly not represented in London today. I think this is where my point about, reader power, consumer power, blogger power, people who can, create their own content, hit back at these kind of, disgusting stereotypes. In that, I cannot imagine drafting a set of regulatory principles that safeguard every reader from offence. And in a way, I mean, it's the ASA, which is the sort of analogous regulatory body I was just thinking of, does actually, on the basis of volume of complaints, normally insist that advertisements that are offensive or misleading are taken down. Maybe you could do something like that in relation to the press, but I mean the best thing is that the decent majority of people who read these newspapers stop buying them. You don't have to buy them, or you don't have to look at them, and cutting off demand through shared public offence is the best way of altering editorial policy.
Thanks. Gill, do you want to add anything?
Very quick, very quick if I may. I can't go into detail because it would waste too much time, but I did send into Leveson what I believe is a complete blueprint for dealing with a lot of these problems. That sounds very presumptuous, but somebody's got to start somewhere. And I have sent it in, and he is going to publish it. But one aspect of that would be with the tribunal, that you would, under my scheme, my proposals, anybody who complained, there would immediately be a hearing in front of one adjudicator. And the journalist, the newspaper, would have to come, and there would be an attempt at mediation. And the tribunal would deal with four things, which is defamation, privacy, harassment, and accuracy. And of course, accuracy, the last one, would be absolutely vital. If you are picking on a group, it gets much more difficult if you're confronted by a member of that group in front of an independent adjudicator. I think it would stop it. But the fundamental point, it's very short, all of this has got to be free of charge, because Tessa said she's absolutely right. The problem at the moment is that if you want to deal with any of these questions, harassment, privacy, defamation, or anything, you've got to be surprisingly rich. And that's wrong. 90-odd% of the population cannot afford to bring one of these actions. If 90% of the population cannot bring an action, how can you say you live under the rule of law? Because 90% of the population don't have access to the courts. So that cannot be right to allow that to continue. So there you are, my 2 cents worth.
Thank you. Gill?
Thanks. It's a really wide question, and it's very hard to know where to start. But I mean, a few points. One, it seems to me, as Tessa said, that this is primarily an issue of internal culture within a news organisation, and these are things that any news organisation should be self-setting standards on, and educating itself on, and listening on, and The Guardian recently had a complaint about, from a mental health campaigner, about the use of the word psychotic, which had been used in a cartoon, and it raised some very serious issues for us about how we were using that word, whether we were using it appropriately. Now these are things that you learn from, and nobody's perfect. We might strive for perfection, but I think we all fall short, and it's really what we do when we fall short, and how we respond to that. I think that there is some backup that can be provided in these instances by the code, which can have things in it which can deal with some of these matters in a general sense. But I think that ultimately, as I say, it's a matter of internal culture. And it comes to mind, I think, the instance where there were I think it was the Suffolk murders, and the women who were murdered were consistently described by all the press as prostitutes or working women, and that's how they were defined. They weren't defined as victims, as women. They were defined by their employment status. And no man would ever be described in that way. And there was a big debate about it, and including within The Guardian, but also at the BBC, as to how you use these terms. And a lot of that is I'm afraid, a learning process. People say these things until someone says to them, hang on a minute, have you thought about that? And that's part of the process.
Thank you very much. More questions?
Terry Doughty of Truth to Power. I'm also on the board of Privacy International, and I was Director of Action on Rights for Children. We dealt for about 10 years with children's privacy and data protection issues. Tessa Jowell pointed out that new technologies are going to make the way that the news is reported very different in the future. And Max Mosley has called for a press commissioner. But as Martin Moore's pointed out, this debate here is only one aspect of a far wider debate that needs to take place. And I'm wondering if rather than a press commissioner, we shouldn't be thinking in terms of an overall privacy commissioner. At the moment, we have various commissioners responsible for various forms of privacy and surveillance, who have overlapping powers, and in some cases there are significant lacunae between their powers. The Protection of Freedoms Bill, which I think has just become an act, creates several new surveillance privacy commissioners of various kinds. There's quite poor communication between existing commissioners, and I think to add a new commissioner into that mix is a recipe for disaster. And I wonder what people think about actually saying the time has come now with the developments in new technologies, some of which the Protection of Freedoms Bill has tried to address, but there will be more threats in the future as technologies advance. And I wonder what people think about bringing together all of them now into one single privacy commission that can actually grow and change as the threats change and can regulate as necessary. Thanks.
I'll take two questions in twos and threes to see how we go. I think.
Hugh, this is really a question for Tessa, I think, but other answers might be interesting. I'm Rupert Gray. I'm a practicing libel lawyer for a good many years. And not infrequently in the course of my practice, it has become very clear that the police have been passing information about arrests to the press. I think this is generally in my field regarded as a widely accepted fact, and has been for some time. Tessa, what I've never understood, given the fact that everybody seems to know this, and nobody's ever actually grappled with it, until possibly now with Leveson. When you were minister, did you not come across this? And if you did come across it, what did you do about it?
Can you just... I'm afraid I had some difficulty hearing the first part of your question.
I'm sorry, so let me start again. Many of the clients I acted for who, for one reason or another, were arrested by the police or were interviewed by the police, when they emerged from the police station an hour or two later, all of a sudden there were 50 journalists waiting for them outside. They got there because they paid the police to inform them that so-and-so had been even just being interviewed, let alone being arrested. So we have this sort of extraordinary device whereby suddenly their reputation is ruined because they've been interviewed by the police. And I made this point a number of times in a number of contexts, and nobody has ever done anything about it other than to say, of course, that's life. And when you were minister for 13 years, or in the government for 13 years, did you come across this? And if so, what did you think about it? What did you do about it?
Well, I mean, like you, I mean, I had constituents who'd had experience of this, and I mean, I think that certainly actually, be careful what one says, but yeah, I mean, it was quite clearly accepted, endemic throughout, allegedly endemic throughout the police force, that the way some police officers supplemented their income was by taking a bit on the side, and there was a sort of almost like a payroll. And certainly I was aware of specific instances in government that, I mean, this would have all been dealt with between the Home Office and the Met or the relevant police authority, cases that were raised and investigated. But what I don't believe that we did as a government was to look at this in any kind of systematic way, and to gauge its extent, gauge its impact, and obviously, you know, with the scale of sort of interdependence that has been revealed, we should have done so. But you know, I mean, I would just say, you know, can I just say, you know, you may say this is all hopelessly naive, and you know, the minute. I mean, I'll tell you, the minute at which I knew that this was, that, you know, Paul Stevenson and John Yates had it, was when the degree of entertainment that they'd had by News International was published by the Metropolitan Police Authority. It was absolutely clear that they'd been caught in this, that they had been lured into and caught in this net. But you know, it is so shocking that you had this relationship, which has now been revealed as a relationship that has led the police to apologise for it. It is so shocking that you know, I doubt if any of us can either remember or can remember, you know, anything on this scale of corrupt symbiosis before. And you know, it's why you know, Sue Akehurst's inquiry and all the other sort of contingent inquiries are important if they lead to a different kind of internal regulatory environment in the press and in the police. And one of the things that, I mean, I have given 4 statements, at least 4 statements to the police. And what has struck me about what the people I've seen, the people from the inquiry have said to me, I mean, they feel ashamed to be associated with that kind of behaviour, and feel that part of the responsibility they carry is to reassert the professionalism of the police. But, you know, there are many who are culpable here for not having taken something which was understood in common practice, to take it more seriously, as a symptom of something even more profound.
May I say something? I think really, with all respect to Tessa, we shouldn't beat about the bush. The question is, why hasn't the Home Secretary in one of the governments, when these things happen, called in the Commissioner of the Police and said, we've got an interesting case here, I want you to investigate and find out. Perhaps he hasn't got the power to do it. If he hasn't, he should, or it should be the Metropolitan Police Authority or whatever. But if you think of a classic case, when the Maxwell sons were arrested, police were knocking on their door at 6 o'clock in the morning. The wife leaned out the window and said, go away, thinking they were journalists, or I'll call the police. And they said, we are the police. Well, it's absolutely outrageous. Somebody should have taken them to court. And of course, these sort of outrageous things were happening in the case where Tamsin brought the judicial review. But it's taken a huge effort. Tessa's right in one sense that maybe we're going to get it out. And I think this will all come out in the Leveson inquiry when we get to Module 2, which is going to be dealing with the police. But let's be under any illusion. Somebody like Hugh Grant said several times, both the House of Commons Committee and in Leveson, when frequently I've called the police over an incident and a journalist has arrived before the police. Well, that's got to stop. But I think the question's absolutely right, and I think it's what we have a government for is to see that this sort of thing doesn't happen. So that's my 2 cents for it. With all respect to Tessa.
Just a couple of points to make. I think, I mean, this is very topical because I think one of the things that's concerning Harry Redknapp at the moment is how the police were on his doorstep, how the press were on his doorstep when he was arrested. And there are issues, I think, that he's still trying to raise about that. So it's by no means an old problem.
You should sue.
I think it's still a current issue about this relationship. And Max is right. The next module of Leveson, which is starting in a couple of weeks, is looking at the relationship between the press and the police. And I think there'll be more sort of popcorn and Coke being eaten around that, because it's going to hopefully get down to, I mean, some of the questions that are being asked already and have been asked of editors about what do you pay to the police, do you pay the police, do you entertain them, do they entertain you, are going to hopefully look at some of those areas. Obviously, Philkin has reported on the Met and has made some recommendations about from their perspective about how they relate to the press going forwards. Whether that's going to make any difference, I don't know.
Can I? Oh, sorry, Martin.
I felt someone ought to respond to Lady.
Well, I'm just going to deal with that now.
Okay.
Privacy Commissioner.
The questioning process slightly got out of hand. Never mind. Back on track. What do members of the panel think about the idea that one way forward is to have an overall commissioner dealing with the whole range of privacy issues? It's a recommendation that was made by the Select Committee and rejected by the government last year, but one that, from an outside perspective, has a lot of common sense. What do people?
One of the interesting things that we've seen with the ICO, the Information Commissioner's Office, is that, in theory, on paper, it sounds I think very sensible, and indeed, the way it's drawn up sounds like it would fulfil some of the roles, not all of the roles, certainly some of the roles you're talking about. In practice, it's starved of resources, starved of powers, and up in Cheshire. And we've seen particularly recently with phone hacking, and well, actually Motorman more than the phone hacking, that for, well, we don't know yet, but for certainly a variety of reasons, the ICO felt extremely nervous about acting in the case of evidence of industrial scale intrusion, and with hands-on evidence of it. So, I mean, in a sense, it seems to me as though the key is really commitment and working out, actually, is this something that the government of the day is going to feel is important enough that they're going to give it the resources, give it the powers, and shift it out of Cheshire probably to at least the major conurbations, so it can have some impact.
I think you should have a tribunal to which anyone can complain without cost, and that should spread over the entire country. It wouldn't cost very much because it could be done by lawyers part-time, and it could be financed by the press paying less than a tenth of a p per copy. It really absolutely essential that ordinary people have access to justice. It shouldn't depend, in my view, on a commissioner that you would then have to approach who might or might not act. If you had a tribunal with clear rules, set up by statute, then everyone would have a means to deal with the invasion of their privacy or defamation and harassment and so on. But you need a very clear body, and you need someone I can go to, you can go to, anybody can go to, and get a reaction. Without that, it's the same old story. They haven't got enough money, they can't do anything.
It's an interesting
Well, wait a minute. Come on. Discipline. Panel discipline.
With New Zealand. New Zealand has just...
Doesn't work. My powers, I need an overall panel commissioner to keep them under control. Jill, do you want to say?
You need an injunction.
No. Thank you. There's lots more people. Sorry, the panel talks too much and the audience not enough. And so there's lots more questions to be asked. I've seen two people over here who are very patient.
My question is for Mr. Mosley. I agree with the press tribunal idea, and it's very important that there's fairness on both sides of the of the line. So with the press looking for this tribunal and believing it's a respectable body, but also the people believing it's a respectable body as well. So my question is, who would sit on this tribunal? Who would you think would make it up to make it a fair body, that the press would look at it and say, well, they're dishing out, justice and a fair deal, and the people would also think at the same time that this body is a respectable body, and it's just not backed up with people from the press or people who don't understand their personal problems?
Absolutely. I think the fundamental thing is that, again, sorry to keep on about cost, but of course one of the benefits of something that didn't cost would also be free to the press, and even the best of the press waste a great deal of money on defamation and so on. I would suggest that the tribunal would be a nationwide organisation. You would have solicitors or barristers all over the place who were part-time working for it, rather like a lot of barristers and solicitors are part-time judges. And they would only be called upon when necessary, they'd be paid, and they would be kept up to date with the law and with all the procedures by the central body. And I think that could be done relatively cheaply. It would certainly cost the press, who would in the end have to pay for it, a great deal less than the litigation costs now. I think the process of having a hearing where you have the complainant and the actual journalist, and they'd have to satisfy the adjudicator that it was the journalist, that process would mean that a lot of it would get sorted out very quickly, but at least you wouldn't have these very, very complex procedures. Final point on that is that at the moment, what we have on privacy, defamation, harassment, all these things, is a Rolls-Royce procedure. The trouble is nobody can afford the Rolls-Royce. What I'm suggesting would be much more rough and ready, but at least it'd be something. At the moment, if you live in a council flat, you've got absolutely no chance of having your rights upheld, and that's got to change.
Tessa, did you want to add a word?
Yes, I mean, I think this is a very interesting discussion, because I think it's sort of beginning to design what might be the right kind of system. And, it seems to me that you could have a privacy commissioner, but with a tribunal who is responsible for setting the broad policy. And I think that Michael's proposition for the public interest test is a very compelling one. So you have policy set by a commissioner, you have it operated by a tribunal, you have I think the tribunal perhaps might just be drawn from members of the public, like you create a jury working to a remit, which is the broad rubric of public interest. I sort of think you also need something which is to do with proportionality. And the final point is you would have to have, do you have representation? And it would be very important that people who would not otherwise want to bring a case to a tribunal could be represented.
Thank you very much. There's a question there on the front.
My name is Geoffrey Forrest. I'm a practicing solicitor. I also happen to be a council member of the Law Society, and I read newspapers. It seems to me that the public interest, the definition of public interest is the key issue, because I certainly would want to be able to read in the pre-Murdoch Sunday Times the thalidomide stories, or in the Telegraph about MPs' expenses, or indeed in the Guardian about phone hacking. I don't particularly want to read in other newspapers about whether one model is taking drugs or whatever. But it seems to me that whether it's by statute or otherwise, nothing should be done to inhibit the press from being able to act genuine in the public interest. And I have difficulty in knowing how you define that public interest. Max Mosley says essentially one's private life is one's private life. Should people in public life be subject to a higher standard of private behaviour? There are really two extremes. You've got prurient reporting at one extreme and public interest reporting on the other. And how, in fact, can you control the former without inhibiting the latter?
It sounds like one of my cross-examinations, and the judge then says, "What's the question?"
I think you...
No questions, no answer. Sorry, more questions.
We might decry Paul Dacre's sexual prowess. I'm going to depart from that. But he clearly has a good product because people buy it. So continuing from public interest and what it means is demand. Can that figure in the definition of public interest, and how does that sit? I suppose because it's Martin Moore's topic, then I would direct that question to him.
No directions, I control this. Sorry, the two more questions I had in the middle here. Sorry.
I think print journalism is fading at the moment. Television seems to be more about entertainment than about news, but at the same time the internet is exploding. How do you see privacy being protected on the internet?
And one more, please.
My question was just following up on the woman about the changes in technology and her question. The question for the panel was, is it time for Parliament to draw the line? But with changes in technology happening so quickly and changing our idea of privacy, and with Martin's idea about, well, maybe cultural constraints can act. Well, it's not culture changing with technology that's changing, and how do you draw the line to address yesterday's problems when we don't even know what tomorrow's going to look like? We might have a different idea of privacy that you maybe want to address. So I'm just wondering, how do you draw that line with all the changes that are happening with technology, with some of the vocabulary that is changing around it?
That's very good. Now, it's a very simple exercise. There are 3 questions. Each panel member has to deal with each question and sum up their position, and has a minute and a half each to do it. Starting with you, Martin.
Well, I'll come to the question that was directed at me first and mainly, which is around, yes, if it interests the public, then is it not the public interest? And the argument that has been made multiple times, which is, look, we sell X many, that's all the judgment we need. No, a couple of responses to that. The first is that once people know what they're buying, I think they often change their minds. Once people knew how news was being gathered by the News of the World, it closed in 4 days. So I think a little transparency can actually have quite a salutary effect. The second is an analogy, not a little forced, but I mean, cocaine. There's an enormous demand for cocaine. It's extremely sought after, but it's very regulated. So I think it's simply using the argument that because there is demand, therefore that's in itself an argument for saying it should not be regulated. I didn't see that. The second around privacy and the lines around privacy, and it comes to the public interest question as well. It seems to me as though Max made an extremely good point, which is that public interest is as much what it's not as what it is. But we don't find that out in the current environment because there aren't these precedents set around principles. There are now being precedents set around the principle of privacy because of where it's set out in Article 8. There aren't around public interest because it's not set out. It seems to me that once you start to set out those precedents, then it actually becomes really quite helpful. So in the Rio Ferdinand case...
No, we're not trespassing into that.
Sorry.
Now stop. I draw the line. No, I think, Martin, the time is up. Sorry.
My time is up.
One of the worst consequences of sort of campaigning journalism over the last 20 years has been the effect of the Daily Mail campaign against immunising babies using the triple vaccine to protect them against MMR. And I was Public Health Minister at the time, and it was the worst and most difficult decision, the most difficult decision that I had to take, to agree that the vaccination programme would continue in the face of this Daily Mail campaign against. A campaign that was shown to be without foundation. In fact, not only without foundation, but to be sort of maliciously and willfully untrue. And as a result, you know, a lot of babies have got measles when they wouldn't have got measles, and you know, all sorts of other complications. Now, I think that was 15 years ago, and I think that had the internet been more mature then, it would have been easier to see a kind of counterbalance to the driving power of a single view. That's all I have to say.
Thank you very much.
1 minute 17 seconds.
Thank you, Gill.
It can be done by a broad definition with a number of items that are presumed to be in the public interest, like corruption and so on, and a number of items which are presumed not to be in the public interest, such as private life, medical records, so on, and that you simply rely on the judges then. Given a broad definition, it has to be in the interests of the public, not merely something that interests the public. Brings me on to the second point, which I didn't fully understand, but I think the idea was that the Daily Mail, because it sells a lot of copies, therefore is in some sense in the public interest. That's certainly something that appears in the Press Complaints Commission. Well, of course, the mere fact of being popular doesn't mean something's right. They used to have huge crowds would turn up at Tyburn to see people hung, but I don't think anybody would say that's the right thing. Unfortunately, people are like that. People will read the Daily Mail, even though it is the most appalling newspaper. And you can't stop them, but you can draw limits on what the Daily Mail do, and perhaps educate the editor at some point about his private life, but that's another matter. Then finally, privacy on the internet, that's a very, very interesting and big question, very quickly. I think in the end, the internet has got to be recognized to be just another medium. It's no more alarming than 1486, when the printing started. It was a revolution, changed everything. The internet is similar. There are two huge problems. One is it's international. The other is that anyone can publish on it. But the search engines and the service providers between them are the ones who give access, and they're the place where you can stop the abuses should this become necessary.
Thank you. Gill?
10 seconds over.
Okay, public interest, I agree that it needs redefining. What I think is that at the moment there are series in the PCC code and elsewhere that they're sort of negatives. They're about bad things. And actually what I think that there needs to be are some positive criteria along the lines that there's a public interest in improving the quality of public debate. There's a good articulation in the BBC code of disclosing information that assists people to better comprehend or make decisions on matters of public importance. I think you have to be careful about not being too highbrow about it, because on the other side of the coin is that just because things are popular doesn't mean that you shouldn't be reading them. Privacy, I would like to see a more realistic, narrower and better focused definition of what's private. Personally, I think the idea that all marital activities, or extramarital activities, I don't want to go into Dacre, all extramarital activities are private, rather misses the reality of modern life. It's complex, but for a balance, listen to Jeremy Clarkson's ex-wife giving evidence before the Select Committee on Monday. She, I thought, gave a very powerful exposition of why she should be able to write the book that she wanted to write. The internet's really tricky, and I actually think the only answer is to educate people about the dangers of it and to stop people putting out as much information as they do about their private lives, because it's never going to go away. And someone once said that the default position in our brains a long time ago was to forget. That's what we did naturally. Nowadays, what the internet has done is change the default position around so that now everything is remembered. And you've got to work in that new environment. Thank you.
Thank you very much.